Good morning, Your Honour. I appear on behalf of the claimant here today, whom in this case is Calvary Charge Tanks Limited. Your Honour, the claimant respectfully requests that the court enter summary judgment for the claimant on its entire claim in pursuant to CPR Part 24. Your Honour, before I move on, might I just ask, have you had a copy of the skeleton argument and the court bundle on behalf of the claimant, and has there been an opportunity to read those? Thank you, Your Honour. Your Honour will see at paragraph 3 to 6 of the skeleton where it lays out the facts of the case, Your Honour. However, I do not intend to trouble you by presenting the facts of the case, but may I ask, have you had an opportunity to read those? Thank you, Your Honour. I'm grateful. Your Honour, as you may see at in the skeleton argument at paragraph 2, there is a list of cases that the claimant intends to rely on here in this application. Your Honour, with your permission, might I move on to address the test for this application here today? Thank you, Your Honour. Your Honour will see that this is addressed at paragraph 7 of the skeleton argument. Your Honour, the test here today for summary judgment is provided by CPR 24.2, which provides that the court may give summary judgment against a claimant or defendant on the whole of a claim or on a particular issue if A, it considers that the claimant has no real prospects of succeeding on the claim or issue, or that the defendant has no real prospect of successfully defending the claim or issue, which the latter applies here today, Your Honour. And B, that there is no other compelling reason why the case or issue should be disposed of at trial. And Your Honour will see at paragraph 8 of the skeleton argument that when considering whether this test is satisfied, the court must also apply the principles laid out in the case of AC Ward. And those two principles are A, that the court must consider whether the claimant has a realistic as opposed to fanciful prospect of success, which was also held in the case of Swain and Hillman. And B, that the realistic claim is one that carries some degree of conviction. And this means a claim that is more than merely arguable, which was held, supported in the case of ED and F-Man liquid. Your Honour, I would just like to move on with the application here today in moving on to apply the application of this test in my submissions. Your Honour, my submissions are, on behalf of the claimant, are addressed in two separate parts, addressing the test in the two parts in turn. And the first test will also be combined of 3 further submissions, and the second part, 1 further submission, Your Honour. In addressing the fact that there is no real prospect of the defendant successfully defending the claim. Your Honour, as the claimant are a company that hire out tanks, the customers tend to come and hire them to use at the claimant's tank park for week-long courses, which they will tend to book in advance. And by the middle of February 2019, the claimant's diary, Your Honour, was fully booked for the period between July and October 2019. And as this period, Your Honour, is during the summer, it tends to get quite muddy at times, which meant that the claimant had some issues with a few particular tanks being of good use, as a few could not sustain the weather and would tend to get stuck in the mud. This had a negative impact, Your Honour, on the customer's enjoyment when coming to rent these tanks out. Your Honour, I'd just like to point out, Your Honour, that this does not occur with all of the tanks, however, just a few as laid out in the clause 2(1)(a), which is exhibit RK1 of the documents that was attached to that was in the pre-reading for this hearing. Your Honour, Mr. Kutyu, who is the director on behalf of the claimant, only reached out, which is a witness in this application, Your Honour, only reached out and arranged to meet with Mr. Tartley, whom is the director on behalf of the defendant, solely for the purpose of sourcing a company that could refurbish, restore and make good the tanks, the tracks for these tanks, Your Honour, in time for the customers to book in July. The other tanks, Your Honour, were absolutely fine, Your Honour, but this was not simply, these tanks were simply not enough for the bookings to be carried out for the customers, as they were fully booked. Therefore, Your Honour, it was quite a matter of urgency that this needed to be done by July. So the claimant, in effect, relied upon the defendant upholding their contractual obligations as laid out in clause 2. Your Honour, it is the claimant's position that there is a clear, evident contractual agreement between the parties here, and that on this basis, the claimant has a realistic prospect of success if the case were to go to trial, as the defendants, Your Honour, are in breach of their contract by not fulfilling their contractual agreement, which is contractual duties, which is supported by the case of Swain and Hillman, as mentioned, Your Honour. And in this case, Your Honour, I'd just like to point out that the Court of Appeal specifically stated that the words "no real prospect of being successful or succeeding" do not need any amplification, and they speak for themselves. Your Honour, the defendant's defence relies upon this misconception of clause 2, and therefore claiming that the contract was void for common mistake. Your Honour, if I may, I would just like to address this in turn, beginning with the correct meaning of clause 2, which is located at paragraph 12 of the skeleton argument of the claimant. Thank you, Your Honour. I'm grateful. Your Honour, if I may just turn your attention to clause 2(1)(b) of the contract, which is exhibit RK1. Your Honour, the claimant does not deny this clause. However, Your Honour, if I could just turn your attention to the witness statement of Mr. Tartley, paragraph 6A, Your Honour, that the defendant claims that this promise to strip away the tracks, as laid out in clause 2(1)(b), was actually separate to actually carrying out the work on the tanks itself, Your Honour, as laid out in clause 2(1)(c) of the contract. And it is stated that in this witness statement, Your Honour, of Mr. Tartley, that the hesitancy was reflected in the wording of the contract. However, Your Honour, it is the claimant's position that it is exceptionally unclear, Your Honour, that any promise to strip away the tanks is separate from this promise to refurbish and restore the tanks. And Your Honour, it is the claimant's position that this contract, it's clear that there's just one contract and there's one purpose of this contract, Your Honour, which is to refurbish and restore and make good the tracks of the tanks. And if one was to read, Your Honour, the contract from an objective standpoint, all clause 2 is doing is laying out the steps of the obligations of the defendant, of how the work is to be carried out. And Your Honour, might I just turn your attention to the case of Wood and Capita, which is located at 12, which is mentioned at paragraph 12 of the skeleton argument, 12B, Your Honour. In this case, it specifically states at paragraph 10 that the court's task is to ascertain the objective meaning of the language which the parties have chosen to express in their agreement. And it has long been accepted that this is not a literalist exercise focused solely on a parsing word of the particular clause, but that the court must consider that the contract as a whole, and depending on the nature, formality and quality of drafting of the contract, give more or less weight to elements of the wider context in reaching its view as to that objective meaning. I'd just like to turn your attention to the defence at paragraph 4b, where the defendant retains that by clause 2(c) of the contract, the defendant is promising to refurbish, restore and make good in the manner set out in the schedule the tanks insofar and only insofar as it was practical to do so, and that it was therefore not in breach of the contract. However, Your Honour, I'd just like to turn your attention to what the contract specifically states at paragraph 2(c). It states, having practically refurbished, restored and made good the tracks for the two Panther tanks and the Sherman M4 tank in line with the specifications set out in the schedule, and having used such equipment as is fit for the said purpose, the defendants promised then to remount the tracks. Your Honour, it is the claimant's position that it is quite distinctively clear what the terms of the contract are here, which is to carry out the work so as to make it practicable for the tanks to be of good use. And while despite, Your Honour, this being evidently clear on the behalf of the claimant, I would just like to draw your attention back to the case of Ward mentioned at paragraph 13b of the skeleton, Your Honour, the claimant's skeleton, which is stated that the contract as a whole, Your Honour, should be considered from an objective standpoint. And it is the claimant's position here, Your Honour, that entering the contract was not based on this assumed obligation as the defendants have, which I quote from the defence, Your Honour, at paragraph 5a. To carry out the work, there's not this assumption, Your Honour, to carry out the work on the tanks, but to simply just carry out the work as agreed in the contract, Your Honour. And this is what should be considered. Your Honour, also the defendants state at paragraph 5, B to D, that the reason why they were unable to carry out the work is because it would not preserve the functionality of the tanks. However, Your Honour, the claimant states that the tanks have been refurbished and restored, as it has been done on many occasions previously. And therefore, Your Honour, any refurbishments to the tanks would not compromise the functionality of the tanks, which is actually mentioned in the claimant's email of Exhibit RK3. Your Honour, the contractual terms were very clear, and it was the defendant's contractual obligation to carry out the work. And Your Honour, clause 2 of the contract evidently lays this out. Therefore, Your Honour, it is the claimant's position that the defendants are in breach of the contract. Your Honour, if I may, I'd just like to turn to the claimant's second submission, and this is addressed at paragraph 15 in the skeleton argument. Your Honour, the defendant did not correspond with the claimant, and this is just in regards to the defendant's failure to correspond, which is quite important here also, Your Honour. The claimant would just like to place emphasis on this. The defendant did not correspond with the claimant until the 29th of June 2019, when notifying the claimant of the fact that the defendant was unable to carry out the works on the tanks. This was 2 months, Your Honour, after entering the contract and after the claimant had delivered the tanks. Your Honour, despite the claimant emailing the defendants on numerous occasions, they did not have an update of any of the work until the 29th of June, when the defendants decided to respond. Your Honour, this did not give the claimants enough time to source elsewhere repair and refurbishment of the tanks. And it is the claimant's position, Your Honour, that this is completely unreasonable and inconsiderate of the defendant, considering the urgency and the deadline that needed to be met in order to fulfil the claimant's contractual obligations to the customers. And these bookings, Your Honour, just to remind the court, was for July 2019. Your Honour, the claimant ensured that the defendant was completely aware of this in their initial meeting in April, prior to entering into any contractual agreement. And Mr. Kutyu, Your Honour, states in his witness statement that he explained to the defendants that time was of the essence. And this is mentioned at paragraph 8 of his witness statement. Your Honour, had the defendant had made the claimant aware that they were not able to guarantee that the work could be carried out on the tanks, the claimant submits, Your Honour, that they would have sourced elsewhere as they needed the tanks refurbished and restored in time for the customers. Your Honour, in considering that the defendant are a business of restoring and repairing vehicles as paragraph 2 of the witness statement of Mr. Tartley, who is the director of the defendants, Your Honour, that clearly laid out that they specialise in vintage vehicles and particularly restoring or refurbishing vintage military vehicles, Your Honour. And the claimant relied upon this, which is why they entered into a contractual agreement with the defendants. Your Honour, due to the defendants' failure in their conduct and in correspondence, Your Honour, the claimant had no option but to source tanks elsewhere and tank replacements, as they did not have time to get their own tanks refurbished and restored. And fortunately, Your Honour, the claimant was able to source this in order to ensure that their contractual obligations were fulfilled and avoid in cancelling any customer bookings, Your Honour. The cost of this to the claimant was actually £34,000 due to this short notice. And Your Honour, therefore, it is the claimant's position that although the court must not conduct a mini trial when reaching its conclusion here in this application today, as mentioned at paragraph 35 of the case of Swain and Hillman, Your Honour, the courts are invited to consider that if this matter were to go to trial, the claimant's claim is more than merely arguable, as it carries some degree of conviction, as supported in the case of ED and F-man liquid products at paragraph 5. Your Honour, if I may, I'd just like to turn to the claimant's last submission of the first part of the test in addressing this alleged common mistake that the defendants seek to rely upon. Your Honour, the defendant concludes that the contract was entered into on the basis of a fundamental shared mistake between the parties, and therefore relying on the contract being void for common mistake, as mentioned in their defence at paragraph 5b to 5c. However, Your Honour, the claimant denies this on the basis that the contract was only entered into by the claimant with the understanding that the defendant would carry out the work, as earlier mentioned, Your Honour. And this to be done before the deadline of the 1st of July 2019, as the contract clearly states that would transpire. Your Honour, the intentions of the claimant were made clear in the meeting held in April 2019, as also mentioned earlier on, and the claimant relied upon the defendant's expertise in this particular area of work. Your Honour, the claimant did not share a common mistake, and this is the claimant's submission here today, Your Honour, that in entering the contract on an assumption that the work may be carried out, as mentioned, Your Honour, and as the claimant would have sourced this elsewhere, alternatively, due to the high demands of the customers and the deadlines that needed to be met. Your Honour, I'd just like to turn your attention to the case of Great Peace and Shipping. At paragraph 76, Lord Phillips, Your Honour, laid down 5 main principles on the case law of common mistake. And therefore, Your Honour, the first principle actually specifically states that there must be a common assumption as to the existence of a state of affairs in order to rely on common mistake as being as voiding the contract, Your Honour. And therefore, if the mistake is not common to both parties, the doctrine of common mistake cannot apply. And therefore, Your Honour, it is the claimant's submission that there are no mistakes common to both the parties. And I'd just like to now turn to the second part of the test in addressing the fact that there is no compelling reason as to why the case or issue should be disposed of at trial. And this is laid out in the skeleton at paragraph 23. Your Honour, the contract was not complex, and therefore the court should use its discretion, Your Honour, to use the text and context as tools to ascertain the correct meaning of the contract, which is to carry out the work on the tanks. This is supported in the case of Wood and Capital, Your Honour, at paragraph 13. The claimant engaged, Your Honour, in negotiations with the defendant, in addition, with a view of resolving the dispute without litigation, however rendered unsuccessful, Your Honour. And this is mentioned at paragraph 17 of the claimant's director, Your Honour. Your Honour, the defendant's error, in addition to this, in the law on common mistake, demonstrates no real prospect of successfully defending the claim also. And this is supported in the case of Easy Air at paragraph 15. And Your Honour, I might just turn your attention also to the case of Danny and Lyons, Your Honour, at paragraph 23, where it was held that in contract, although a party may not carry out the work required, as they then realise it affects the functionality of the subject, it does not relieve a party of their obligation of performing its contractual duty. And therefore, Your Honour, the claimants submit that there is no compelling reason as to why the case or issue should be disposed of at trial. And the claimant, therefore, Your Honour, respectfully invites the court to enter into summary judgment for the claimant on its entirety of its claim. And if there are no further questions, Your Honour, those are my submissions. Thank you, Your Honour.